All right, this is case number 2240637. This is Byron Bogan versus Stephen Bennington and Motor City Electric Utilities Company. Today is the time set for appearing. Your appearance for let's see, do we have counsel for the, well, let me have counsel for the defendant in this matter, first of all, your appearance at this time. Counsel for Bennington, Stephen Bennington, Electric Utilities.
Judge, the attorney called, they're on in another court, his clerk secretary called, and the attorney is in another court. He said he'll try to get on shortly.
All right, thank you. Mr. Byron Bogan, I see that you're present. Good morning to you, sir.
Morning.
All right. I'm waiting on the other side. I'm going to be coming back to you, Madam Sir, so just stand tight. Okay. All right, this is case number 21-166-312. This is Dearborn Pain Specialist PLC versus City of Detroit. The matter is before the court, set on, I believe that there is, I have the notice of a jury demand. Your appearance at this time, please, for Dearborn.
Good morning, Your Honor. Gary Blumberg on behalf of the plaintiff Dearborn Pain Specialist.
Good morning to you, sir. Let me have your P number, Mr. Blumberg, if you will.
I try and disguise that, Your Honor. P29820.
Yeah, that's the numbers of legends. All right, City of Detroit, if you will, at this time.
Cheryl Ronk on behalf of the City of Detroit, P number 54897.
All right, Ms. Rock, good morning to you, ma'am. All right, so what's going on here? I see it looks like this is just getting started. So you've not had any discovery or anything going forward in this regard, is that correct?
No, Your Honor. This is a second generation lawsuit, and I noticed that the city hadn't answered, so I contacted Ms. Ronk last week, and they, I believe, filed their answer, and we're proceeding. So we're just getting started.
All right, very well. So what do you need going forward? I know you're just getting started, but you said it's a second generation, so you got everything all worked out, or you got all the discovery you need?
I don't need anything myself. Whatever Ms. Ronk needs is fine with me. But
I mean, I probably need about 60 days just to catch up on what is going on with the underlying client. I thought that he had stopped treatment. So just for me to catch up on what's going on, I probably need about 60 days of discovery.
All right, it makes sense to you, Mr. Blumberg?
absolutely, Your Honor.
All right, very well. The court will formally open discovery with regard to this matter. I don't have the filing of the answer, or it's not contained in the file yet. I'm sure it's going to catch up, but I'll go ahead and open discovery in this matter over the next 60 days. I'm going to give you a pretrial conference date just beyond that 60 days. That date's going to be this one.
January you want to do the 19th or the 20th? Or you want to go further?
No, that's about 20. Yeah, 20.
Okay, that's a Thursday. Yes.
So I'm looking at January 20, 2022, and that's going to be at 9:30 a.m. January 2022. That's going to be the discovery cutoff, and that's also going to be the next hearing date. Now, so what I'm going to do is, and I'm also going to give you an opportunity, if you wish, to file motions by that date. Now, it's not the ultimate cutoff or anything, but I'm going to give you the opportunity to do so. If you have any motions that you wish to bring before the court, they can be heard on the 20th of January at 9:30 a.m. So long as you file your motion, giving the other side at least 7 days to respond to the motion. So that can be dispositive or non-dispositive motions, whatever nature, as long as you give 7-day opportunity for the opposing party to respond to the motion. I will hear it on the 20th of January 2022. If you need more discovery at that time, the case is moving along, then let me know at that time. We'll address those kind of issues. But if you move the case in a position where the court should consider some some motion that you wish to bring, I will certainly consider that. Again, I know I'm being repetitive, so long as you give the other side at least 7 days to respond to your motion, right? You'll get a notice from the court concerning the next action date. Again, I repeat this, the 20th of January, 2022 at 9:30 a.m. I do wish you to do well. I'll see you soon.
Your Honor, if that's it, thank you very much. It's good to see you and have a good day.
Thank you.
Likewise, sir. See you both of you. Have a good day.
Thank you.
All right, the court now calls case number 21-15-1911. This is ASP Cares Pharmacy versus Auto Insurance, that Auto Owners Insurance Company. The matter is before the court. Looks like I have it scheduled for a general hearing, but your appearance for the plaintiff regarding this matter, please.
Good morning, Your Honor. Helen Cooley on behalf of plaintiff.
And
And
Ms.
good
Cooley,
morning. I'm sorry, Your Honor. Good morning, Your Honor. Jalise DiBiase on behalf of defendant auto owners.
All right, and let me have your P number first, Ms. Cooley, if you will, for the record.
I'm sorry, it's B84581.
All right, thank you, Madam Counsel. If you would do me the same, your P number, if you will, for the record, please.
Yes, Your Honor, that's P79916.
All right, thank you very much. So go ahead and update me at this time, Ms. Cooley. I remember something about this case, but update me if you will.
Your Honor, defense filed a motion, MST, and it's supposed to be heard today.
That's correct.
All right, I believe that I've reviewed that. All right, so hold tight. Let me come back to your matter in just a moment. Mr. Blassie, you filed a response to the same, is that correct?
I did. I'm sorry,
Yeah.
Your Honor.
We
Sorry.
filed the motion, plaintiff filed a response. It was late and we didn't get a copy until Friday afternoon, which is why we did not file a reply. However, if the court wishes, we are ready to proceed today.
All right, so I'll come back to you in just a moment, okay?
Okay, thank you, Judge.
All right, the court is calling case number 21-147838. That is the case of preferred rehab care versus City of Detroit, and your appearance for the plaintiff regarding the preferred rehab.
Good morning, Your Honor. Sharif Arif, appearing on behalf of plaintiff.
Your P number, Mr. Aaron.
P74522.
All right, thank you. Good morning to you, sir. For the City of Detroit, your appearance at this time, please.
Yes, Your Honor. For the City of Detroit, Gina Smith Gallant, P number 41387.
Thank you, Mr. Gallant, and good morning to you as well. And I do see that there is a motion for summary disposition has been filed regarding this matter as well. Any other issues that need to be brought to my attention at this time?
Nothing on my end, Judge.
Yeah, I set up a scheduling order and gave you some time to do some discovery stuff, and then set this date on. So you're expecting the day that you would be heard on a motion that was filed in this matter. Is that correct?
Correct.
Correct.
All right, we'll address that in just a moment. This was. All right, so I'm coming right back to you in just a moment. I have the case of Ohana America versus Detroit 2000 Land and Home Development under file number 21-162-818. Your appearance at this time, please.
Morning, Your Honor. Stephen Lynch, P70211. I'm appearing for the plaintiff today.
All right, thank you, counsel. Good day to you. For Detroit 2000, your appearance at this time, please.
Yes. Jeffrey Hendricks of Detroit 2000 Land, Home and Development.
All right, thank you, sir. You're not represented by counsel at this time. Is that correct, sir?
Correct.
All right.
No, I'm not represented by no counsel.
All right, thank you, sir. And this is, this matter before the court on the filing of a subpoena, the issuance of a subpoena by this court ordering that the defendant Jeffrey Hendricks appear in any person representing Detroit Development for purposes of disclosing information that arises as a result of a complaint that was filed in this matter and a judgment that was entered. Looks like that judgment is a judgment that was entered in a foreign jurisdiction for the amount of some $10,605. All right, so I'm going to give opportunity for both sides to talk about this and to give answers under the subpoena in a breakout room. That makes sense to you, counsel?
Yes, Your Honor.
All right, and so given that this is a subpoena, sir, Mr. Regarding, I should say, Detroit 2000, Mr. Hendricks, I'm going to place you in a breakout room. You're required to answer questions under oath regarding assets and resources that you may have that may be held by Detroit 2000 and home development doing business at Detroit 2000. You understand that, Mr. Hendricks?
Yes, I do.
All right. Is there any other agent appearing on behalf of or with the Detroit 2000?
I'll just see if you can settle this right now. I'll judge.
Yes, sir.
I have a question. I was wondering, can I settle this right now?
Yeah. You want to talk with the other side to see if that's something that you can do, sir.
Okay then. Okay.
I'm going to put you in a breakout room with Attorney Lynch and raise that issue. And you'll have the opportunity to come back in, both sides will, into the courtroom and let me know if you need further involvement from the court. Right now, there's the issue of the subpoena. So I need you to raise your right hand and be sworn this time, Mr. Hendricks. You do solemnly swear affirm that the testimony statements that you give relative to assets and resources and the effort to get this matter resolved will be the truth to the best of your ability. So help you God.
Yes, I do.
All right, thank you, sir. So you'll get a notification from me in just a moment to go to breakout room number 1, and Mr. Lynch is going to receive the same. And I'll see you in just a moment.
Thank you, Judge.
I know that I have do I have counsel for Bennington, Motor City Electric on at this time? All right, very well. We'll get back to you. Mr. Morgan, I know you're still there, sir. All right, we're back on the record in the suffix 2151911. That's ASP Cares Pharmacy versus Auto Owners Insurance. And you've entered your respective appearances in this matter. And you may proceed with regard to your motion in this matter.
Thank you, Your Honor. This is defendant auto owner's motion for summary disposition based on the lack of cooperation of the underlying claimant, Andre Sewell. The accident in this case occurred in March 14, 2020. Underlying claimant allegedly sustained injuries, and ASP Cares Pharmacy alleges that it provided Sewell with medical treatment following the accident. Before the suit was even filed, auto owners, in the attempt to investigate this claim, scheduled 2 different IMEs on September 23rd, 2020, and again on October 28, 2020. Sewell failed to attend both of these IMEs. Due to his failure to cooperate, a letter denying benefits was sent to him after the second missed IME. Then after the suit was filed, auto owners scheduled an additional IME on August 30th, 2021. We spoke with Sewell. He confirmed he was going, but then he still failed to attend that one as well. So we have a total of 3 missed IMEs. And judges, we outlined in our brief, under Michigan law, auto owners can indefinitely suspend benefits, and there can be no breach of a duty to pay when there is a repeated failure to attend an IME. And this is not a one and done situation. We gave him multiple chances to attend IMEs over the span of a year, and he failed every single time. The claimant has a statutory duty as well as a duty under the policy language to attend IMEs so that we can investigate the claim. And we have been unable to do that here. Specifically in Roberts v. Farmers, the appellate case cited in our brief, specifically says an insurer may properly suspend benefits when a claimant will not cooperate for an IME because it keeps the insurer from being able to properly investigate a claim. ASP Cares alleges that we breached our duty to pay benefits, but the law makes it clear that because the claimant failed to cooperate and breached his statutory duty and duty under the policy, that auto owner's non-payment is not a breach of any statutory duty. So because we have no duty to pay Sewell's claim, we also have no duty to pay ASP Care's derivative claim due to his continual failure to cooperate. So for those reasons, Your Honor, and the reasons stated in our brief, we ask the court to grant our motion.
The two significant issues here is the allegation of the lack of cooperation with the claim, and they claim that the enforcement of the contractual benefits rights is contingent upon cooperation with the same. Secondly, that the derivative claim stands or falls on the cooperation of the injured party. You may respond at this time, Ms. Coleman.
Your Honor, this case was filed on behalf of plaintiff, and the complaint was filed against the defendant. Mr. Sewell did receive treatment from ASP Care's facility from April 27, 2020 through September 27, 2020. The total bill is $9,711.56. If Mr. Sewell did not cooperate for not attending his IME appointments, this has nothing to do with the ASP derivative suit. They have a direct cause of action to file suit on their own behalf, as the no fault allows them. They will be unduly prejudiced if the bill does not get paid. His lack of cooperation for not attending the IME appointments is in dismissing the case will be severely prejudicial to plaintiff. However, Mr. Sewell did attend his deposition recently in August 26, 2020 via Zoom. Plaintiff has no information regarding the circumstances to plaintiffs not attending the IME and what's surrounding those circumstances. Therefore, it will be unduly prejudicial for ASP Care's case to be dismissed due to Mr. Sewell's lack of cooperation in not attending the IME appointments. Therefore, the plaintiff asked the court to deny defendant's motion.
You're indicating that the defendant, the claimant in this matter, the underlying claimant, that is Andre Sewell, that he attended under subpoena, he attended a deposition in this case?
Yes, Your Honor.
And how long ago was that again?
That was August 26th.
All right, so and was there any special compunction or any need to do any special compelling for the defendant to appear at the deposition, to your knowledge, Ms. Coleman?
All I know that, Your Honor, he was subpoenaed and he attended. I'm not sure how that was arranged, but I appeared for it and he did as well.
So, Mr. Blasey, you subpoenaed and noticed the defendant to appear for a deposition. Is that what it was? Or
That's
I should
correct.
say, Mr. Sewell, I should indicate.
Yes.
Was there any inquiry made or at that time regarding the MRIs or his participation in the same, refusal to participate? Was any of that raised in the deposition?
I don't believe so. I don't believe he indicated why he previously failed to attend an IME.
Right.
He was not asked about those circumstances, Your Honor.
All right, thank you. So, Ms. Coley, it seems that the issue that you primarily defend on as it relates to the motion for summary disposition is that, notwithstanding what Mr. Sewell may have done, if there can be an establishment of treatment that the derivative claim can be treated as a independent action, as in some sense it is anyway, notwithstanding the conduct of Mr. Sewell. That's your argument, is that correct?
Yes, Your Honor.
You don't dispute that Mr. Sewell could in fact vitiate or cut off his claim by his inaction or lack of compliance with contractual obligations under the insurance contract, as well as in relationship to statutory provisions that require his cooperation. I don't know that you need to, well, but are you disputing that his claim could be cut off because of his refusal?
Your Honor, his lack of not attending the IME appointments, I understand the no fault requires him to attend them. However, as stated before, the plaintiff has a direct cause of action to, as you know, the no fault allows them to file and have their own action to get their bill paid. It is related somehow. However, him not attending the IME appointments may prejudice the plaintiff from not getting paid for the services rendered to him, especially for medications that was prescribed to him for a total of $9,000.
And so, Madam Counsel, kind of the argument, two things may be alike or one of two things may be different. Counsel argues that while there may be a prescription against recovery as relates to Mr. Sewell because of his lack of participation at MIs over a period of 3 notifications, that should not prejudice the rights of the defendant herein, particularly where the legislature had allowed for independent cause of action by the plaintiff in these type of cases. So I get your argument, but I want to hear a little bit more as it relates to how the underlying defendant refusal to participate in the MRIs would give rise to the cutting off of the benefits derivative bill they may be under a direct claim that can be brought pursuant to the legislature's determination of the same and the formulation of the same by case law as well. May at this time.
Your Honor, may I reply?
Yes.
Thank you, Judge. First of all, I want to point out in plaintiff's response, they don't cite any law. They don't really cite anything to support the position that they presented today. It essentially says they don't know why he didn't attend his IMEs. Maybe he was busy at work, which is irrelevant. It also says, she mentioned they have an independent cause of action. However, we did address this in our motion. We cited TCBI versus State Farm, which indicates that a medical provider's claim is a derivative claim and they stand in the shoes of their patient. So if a patient breaches their duty and cannot collect benefits, then neither can the medical provider. And he breached his duty in 2 ways, statutorily and under the policy language. And again, not just once, but 3 times. So again, we asked the court to grant our motion based off of his breach of duty, which affects the medical provider derivative claim. And also, we are prejudiced in the fact that we have been unable to properly investigate this claim due to his failure to cooperate.
All right, counsel, what of the TCBI case, if you will?
Yes, Your Honor, one moment. It is PCBI versus State Farm Mutual Auto Insurance Company. It's 289 Michigan. Oh, 39.
I was actually directing that to Ms. Coleman.
Oh, I'm sorry.
Your Honor.
Yeah, I was asking you about the TCBI PC versus State Farm case, which is a 2010 case. I believe there may have been some changes since that time, but it's a 2010 case that seems to stand for the proposition that a derivative claim could be effectively denied where the defendant refuses to participate or has breached a duty under the contract. That was in the defendant's, I should say, the defendant's brief in this matter. So I'm making reference to that case and wanted to know if Ms. Coley, you had anything to say about that case.
Your Honor, the plaintiff relies on Covenant Medical Center versus State Farm. That was recently in 2019 that was amended, and like I stated before, that allows the plaintiff to file a direct cause of action against the defendant and have their own suit and collect medical benefits.
Now, I don't have the benefit of, for some reason, I don't think I have the benefit of your response to the motion for summary disposition. I'm just taking another look here. But you cited a particular case that you're looking to, Ms. Coley.
Your Honor, it's not cited in the brief, but I have the case.
All right, let me have the case that you're citing.
Sure. It's Covenant Medical Center versus State Farm, 500.
Let me stop you because, we get a little cloudy on this. You said Covenant Medical Center?
Yes.
Versus?
State Farm.
All right, and what's the site on that, if you will? I want to take a look at it.
500 MICH 191 2017.
All right, so I need to take a look at that case and see what impact this has on this particular case. It does seem peculiar to the court that the legislature statutorily would allow for separate claims by providers, thus giving to providers the, if you will, the right to rely upon the insurance contract in a derivative claim, and that on the other hand, that they would be cut off from any ability to recover after incurring expenses in anticipation of being paid because the claimant cooperated with treatment with them, but didn't cooperate with treatment under the contract with the insurer, I should say. So I want to examine that a little bit. Moreover, the concern that there is that there might be a remedy available short of completely dismissing and denying the plaintiff's claim period. And I'm wondering if the court ordering the defendant to appear for an MII short of ordering him to appear for an MRI might cure the issue in this case.
Judge, sorry to interrupt, but I need to, with that regard, I need to let the court know, after we filed this motion, after all of this occurred, we received news a couple months ago that the claimant passed away. So there won't be a chance for him to attend an IME now. So the prejudice against us to and be able to investigate this claim is now solidified, as he will not obviously be able to. However, we present to the court that doesn't affect our argument or position at all. The facts and law remain the same, that he still failed to attend 3 different times. He still breached his duty under statute and the policy. So our position remains the same, but I do need to let the court know that.
Oh, yeah, I appreciate you chiming in and letting me know that, because that is an important part of this. But I got you already on the other items. I know the position that you're taking this matter. All right. So what I need to do is, since that case was not cited in the plaintiff's brief, I want to take a look at that particular case before making the decision on this. Do you have time to come back in tomorrow, say at 10 o'clock a.m., so I can make a ruling on this? If you have time to do it then, or I'll set another time.
Judge, I'm able to do that tomorrow.
Ms. Coleman?
Tomorrow at 10, Your Honor?
Yes.
I do have an EUO scheduled at 10 tomorrow. Can we appear before or after?
Sure. I mean, I can do it at 10:30. I can do it at 9:30.
9:30 works.
9:30 work for you, Mr. Gleason?
Yes, Your Honor. I do have a quick question. Because that case was not cited in plaintiff's response, and it's just been brought up today, will I have a chance to reply to that at tomorrow's hearing?
Yes, absolutely.
Okay.
I want to take a look at it, and I'll give both sides an opportunity to express your thoughts about it in court, make a decision.
Okay, perfect. Thank you, Your Honor.
Thank you, Your Honor.
I appreciate your indulgence in this matter, and we'll see you tomorrow at 9:30.
Okay.
Thank you, Your Honor.
Have a good day.
Okay, we're back on the record regarding the suffix 7838, and that is Preferred Rehab versus City of Detroit. All right, you've been at your appearance and
Good morning, Your Honor. Sharif Arif, P74522, appearing on behalf of plaintiff.
all right, got you.
Good morning, Your Honor. Gina Smith Gallant, 41387 on behalf of the City of Detroit defendant.
All right, and I see that this is the city's motion for partial summary disposition. And you may proceed at this time, Ms. Gallant.
Okay, Your Honor, this is the city's motion, and the motion is for summary disposition based upon unreasonable and unnecessary charges against the no-fault statute. Your Honor, to date, the plaintiff clearly has the burden of proof by case law to establish that these charges are reasonable. To date, we don't have anything but a self-serving affidavit and the bills and the invoice. That is not enough. And it's clear that a health provider must charge reasonable charges in order for the insurance company to even be bound to pay, for liability to even kick in. In this case, it hasn't been done. This plaintiff charges over $18,000 for physical therapy. And Your Honor, I would like to bring your attention to, I believe it's Exhibit F, which clearly shows that, and this is, and I cite the case of Spectrum, which is cited in our motion, to show that these charges are clearly unreasonable. It's almost half the same amount. We have outlined Medicare and private insurers approved payments, and they're less than half of the 150 and so forth payments of the plaintiff charges. So we think that these are applicable. We have presented proof that even though it's not our burden, that these charges are unreasonable, and we don't see any like proof from the plaintiff, except for their own affidavit that they own the company and that here's what we charge. That's not acceptable.
All right, you made reference to an exhibit F. I'm looking at your motion for summary disposition. It looks like I see exhibit A through C.
There's let's see, Your Honor, there was a supplemental.
I do see the supplemental. I didn't
Is
see
there
I didn't see any tab, but I do see that you have attached the claimant's billing configuration. Is that what that is? Okay, I see what you're doing. All right. So
You see it?
Gave me tabs at first, and now you give me exhibit by sheet section.
I'm
Okay.
sorry. We did have a break in our administrative. We lost an administrator a couple of weeks ago. So I'm sorry if that's changing threw you off, but you do have it. It is a report by Tammy Rockholt. She's an RN and a utilization specialist, and she has clearly compared what Medicare pays and what the automobile insurance pays. Private insurers pay. And this is relevant and admissible according to Spectrum. We don't have anything like that from plaintiff. And so at this point, it's undisputed that it's unreasonable. The charges are unreasonable.
All right, so what are you asking the court to do under your motion at this time, Adam?
We're asking the court to dismiss based upon the charges. Specifically,
On the argument that the charges are unreasonable, correct?
that they're unreasonable.
All right, thank you, counsel. All right, Mr. Reed.
Yeah.
It's a bunch. It's $18,000, and it's supported by something of an affidavit. Tell me a little bit about this.
Sure. Sure. So, Judge, first of all, I'm just very confused by the second motion for summary disposition. The defendant, as the court knows, the defendant filed the exact same motion for summary disposition months ago, which was heard and denied by this court. After it was denied, the defendant came at the settlement conference and said, wait, we have evidence of fraud on behalf of one of the patients, Ashley Henry. And that was to be the basis of this motion. And as you can tell, that was not mentioned at all during the oral argument, nor was it the focus of the second motion for summary disposition. In other words, this is just a second bite at the apple. It's nothing more than that. This was already heard by this court. It was denied by this court. In fact, I would go as far as to say that I think that defense's posture at the last settlement conference misled both the court and I into believing there was going to be a new basis for this MSD, which there clearly is not. So I just want to make that clear for the record. Now, we can again go into this for the second time. That's not a problem. On page 9 of my brief, I clearly mention the applicable law here. I cite many cases: Spectrum Health versus Farm Bureau, Bronson Methodist, Advocacy Organization for Patients and Providers versus Auto Club, to name a few. And in those cases, they summarize the ways in which a medical facility can come up with their billing rates. And the affidavit clearly is consistent with the case law that I attached to my answer, which allows the plaintiff to compare and contrast their rates with other medical facilities within their geographical area. There's nothing out of the ordinary in terms of the billing rates in this case. Also, the billing rates are regarding 3 patients. So it's 3 patients that total $18,775. And again, at the last hearing, we were told by defendant that this MSD would revolve around Ashley Henry's fraud.
Right.
And that was not mentioned, and that's not the basis.
Mr. Reed, you mentioned that point twice already. This your third time on that point, but I got you on there. So your argument, I got your initial argument to this is that it's a rehash and that it's already been determined by this court and that the court should not revisit this issue. Your secondary argument is that that your client, or you have provided on behalf of your client a reasonable analysis that survives any argument that the charges are unreasonable. And then tertiary or thirdly, you indicate that these charges are particularly reasonable in light of the fact that they relate to three different individuals. Correct, counsel?
Correct.
All right, Ms. Gallant, I know that.
Yes. I think counsel has brought up an issue that this is the motion that was based upon fraud. This motion, I believe my colleague, Francis Burns, did bring up the fraud, and it has been filed. It says second MSD based upon reasonableness of charges, motion based upon fraud. And does the court have that?
Let me look a little bit further
If
here.
not, then I would ask that we can argue at a different time because the court needs to have it. It's based upon testimony of Ashley Henry.
Yeah, that would likely be a motion that was filed on the 1st. Yeah, on the 1st of November. I have that timestamp, November 1. So yeah, I see I've been listening to arguments on the motion from August the 2nd that I believe Mr. Reed correctly indicated the court made some determination in regard to that particular motion. I also have the November filing, which is a defendant's motion for partial summary disposition, and it relates to
The medical necessity.
No, it relates to the fraud, the
Right.
allegations of fraud for Ashley Henry. And
Right.
you're arguing, you're using that to re-argue something that we already argued and ruled upon already.
Well, actually, it would go to the supplemental would go to the reason medical necessity. If they can't prove that they treated Miss Henry, then it would be, it would go to whether it was medically necessary under the same statute.
All right.
Okay.
So I'm starting to get it now. Apparently, there was a motion that drilled down on the issue of whether or not the charges were reasonable, and the court made some determination with regard to that motion, and the plaintiff survived that aspect of the motion. Then a subsequent motion is brought arguing issues of fraud, and that as a result of that, that the medical services were not necessary. And that's the motion actually before the court.
Let me see.
All right, so I'll come back to you, Mr. Reed. Ms. Gallant, go ahead and tell me what you wish to tell me in this regard.
I'm sorry, did you ask me or Mr. Reed?
Yeah, I'm back to you, Ms. Gallant. You made it this time.
Yeah, so the plaintiff is saying that they treated Miss Henry. Miss Henry is saying that there was a conspiracy, they conspired, and that they conspired to bring her to treatment. And that's the basis of the fraud. That was the second part. It's set forth in the brief. I am going to rely on the motion and the brief in terms of her testimony and that.
All right, Mr. Reed.
Because
Oh,
and I direct you to I think it's page 11 or I don't want to read the whole testimony in, but there is no, there's clear testimony that they didn't perform the kind of services that they alleged they performed, and that it was a conspiracy to bring them to this place in the beginning.
All right, and so all right, and I know that you are arguing that that should relate to Ms. Henry's claim, but you're saying that by virtue of Ms. Henry's testimony, that should relate to all of the claimants and the service providers in relationship to these claims, correct?
Correct, but at least with respect to Ashley Henry, but she's speaking of all of the claims. Because once fraud is invoked, then it carries out for all of them.
All right. Mr. Lamb, thank you. Mr. Reed.
Yes, so in regards to, well, first of all, I just want to make sure the court has plaintiff's response to the second motion for summary disposition.
I saw your response to the first item, and I've been looking to see if I saw something later than that. But the latest that I seem to have from you relates to sometime in September. But let me take another look here.
Sure, because we did file a response to this on 11/9.
Yeah, and I don't have anything that late from you, sir. One more look at something. The latest response I have from you is sometime in September. So I probably should let, obviously you filed it, it's just not, it hasn't reached me. But I probably should adjourn and allow you to get that to me, although it's not your fault.
And Your Honor, I just want to make sure, that you do have our second motion. You do have that, right? Based upon the fraud. You have that with all the exhibits, the testimony of Ashley Henry, correct?
Yeah, I have a document that's dated November 1, and that document is specifically addressing those issues, and it has attached to it exhibit A, B, and C.
Okay, that's correct.
Well,
Judge,
I don't have a problem with that then.
Judge, do you have an email I can send it to by chance?
Are you prefer rehab?
Yes.
Okay, yeah, sure. This they sent it today.
It came up today.
Okay.
And so I haven't had a chance to look at it at all.
And Your Honor, I would like for you to brief all of it, and I acknowledge that the testimony that we've submitted by Ms. Henry is pretty long, but I would like the court to be fully advised. So I don't have a problem if the court wants to adjourn it and bring it back.
I mean, I don't either.
Yeah, I think that's the right thing to do, because I pulled stuff up. I remember the case, and then I'm looking through a motion that I have read already.
Right, and it is a different motion, and I'm sorry that it has been filed, but I didn't bring that up.
Yeah, got it. So I've got the motion and I've got the response. So give me, I'll need just a little time to kind of make sure that I'm up on everything that's going on here. All right. So, and it's hot off the press, Mr. Reed. Yours just came up from about.
All right. Fair enough. Thank you.
Do we need to repress a P, or will this just be a date that you
I'll give you a date right now.
Okay,
We can get this done, all right? So let me just organize a couple of things here.
okay, no problem.
So can I squeeze it in somewhere?
We don't have, you only got that one week of December, that's it. And then you have January,
20,
so you have the end of this, where's
24?
the 24th of this month. Okay, well, you can squeeze it in. You wanna do 29th? You have 4 on that case, you got 9 on the 24th.
I don't want to put it out there. Okay, the 29th of November. All right, and I can get you back in here again. The 29th, 9:45.
Okay, that's a Monday, yes.
Thank you.
Thank you, Your Honor. I think that's fair.
All right, thank you. We'll see you at that time, the 29th at
All right.
9:45.
Take care.
Thank you.
Okay, and counsel on Ohana, are you back on that matter? One second.
I'm sorry, Judge, I missed it. What case did you say?
Not on yours just yet, Mr. Bernardi. I was looking for counsel on, I was looking for Mr. Lynch. Mr. Lynch, are you here, sir? All right. It looks like on the suffix 2818, that was a subpoena, post-judgment subpoena, and the parties were in the breakout room to discuss what would happen next. So the court is going to conclude that they have, that the subpoena has accomplished its purpose. And I am on the record regarding the suffix 0637. That's a recall on Bogan, strike at Brian Bogan versus Stephen Binning and Motor City Electric Utilities Company. I was advised that counsel for Stephen Binning's was in another hearing, so the court set the matter over. Mr. Bogan has been here for the duration of this time. Your appearance for defendant regarding this matter.
Good morning, Your Honor. Ross Brunetti on behalf of defendant, and I do apologize for my tardiness. Macomb County Circuit Court. I just got out of a hearing in there, Judge.
Thank you, counsel. Just indicate your P number, if you will, for the record, sir.
P73080.
All right, thank you, counsel. And as I indicated, Mr. Bogan is in fact present regarding this matter, and I believe that there is I know that that the court entered an order dismissing the case at one point. There was a motion for reinstatement. Mr. Brunetti, advise as to where you believe this case is at this point.
Yes, Your Honor. This case had previously been dismissed for plaintiff's failure to appear for some motions that were set. Plaintiff then, I believe, appeared actually at the courthouse, and the case was reinstated. We have been here once or twice since then, and the reason being Mr. Bogan had been trying to provide some sort of proof that his vehicle was insured at the time of the accident. If it was not insured, then he is not entitled to recover under the law, and his case must be dismissed. If he was insured, then he may be able to proceed with this case. My understanding is that then this is my understanding. We'll see what he says in a moment, Your Honor, but he had asserted at one time that he had obtained Progressive insurance and that he was trying to get them to backdate the policy to cover the date of loss. And we were waiting to see what sort of information he provided.
Yes, and I note that I indicated that I would set the hearing on the date, and I set it as a show cause date, where the plaintiff must show cause why reinstated motion for summary disposition should not be granted. So this was that date set for give Mr. Bowman, quite frankly, as much leeway as possible to establish that the vehicle was insured at the time of operation. Mr. Bowman, you may at this time update me on where you are with this matter, sir, in light of what I've indicated.
Yes, I did receive some information from Progressive, but no, it shows that they were not able to backdate it, so it was not insured during that time.
All right. Well, unfortunately, the implications of that is that you can't proceed on the claim where you're the owner operator of an uninsured motor vehicle. If they won't backdate it, that puts you in a position where the vehicle was uninsured at the time that it was being operated. Under those circumstances, I would be inclined to grant motion for summary disposition in this matter and find that there is not a cause of action that we recognize under the state law as it is currently configured. Anything else anybody wants to bring to my attention at this time?
Judge, would you like me to submit an order?
Yes, sir. Let me hear from Mr. Bowman for just a moment.
Okay.
Mr. Bowman, anything else you wanted to tell me at this time, sir?
No.
All right. Yes, Mr. Renetti, if you would submit an order to the court, that order granting the motion for summary disposition regarding this matter, which would result in the case being dismissed. Do so at the following email address. That is.
I apologize, Your Honor. Let me just get ready to type it down. Okay, I'm ready.
That's Latifah, LATIFAH .Hunter at 36.
HUNTER, okay. At 36.
Yes, 36th District Court.org.
I've got it, Your Honor.
All right, very well. And Mr. Bowman, once that order is entered, a copy will be sent to you as well. And it's just the same thing that I've ordered here, that the motion for summary disposition is granted and the case is dismissed because of the no insurance situations. All right, I wish you well. Good day to you.
Take care.
All right, I see two attorneys, and tell me what you hear on. Did I miss something?
We're here on a pretrial on Cherie Thurman, 18-003272. And it should be pretty fast.
Sorry, I didn't have that one on my calendar.
I don't have it. We'll say it's 18 who?
Yeah, let me have that case number again, if you will.
18-003272 NI.
No.
I have a different case number, Brian. I think it's 19170659.
Sorry, I'm using the Wayne County case number before it was transferred to you. So.
Right.
Thank you, Steve.
You said 19170699?
0659.
It's not on there, but it is up for today.
It's the second one on the docket, Latifah.
Yeah, it is on there, Judge. 9:30. Hudson. It says Thurman Cherie.
Thurman, yeah.
Yeah, I don't have a problem with it.
Oh.
Let me see, maybe. All right, gentlemen, I do have that case number 1917-0659. This is Cherie Thurman versus Homeowners Insurance. It was in fact on my docket. I didn't have the file, so we kind of got that passed. Thank you for your patience in this regard. Looks like it is before me for a pretrial.
Yeah, the only thing that we wanted to bring up today, Your Honor, is we have agreed on a facilitator, and we are working to get a facilitation date. And we think that we can resolve it at facilitation. So we're hoping that you allow us to go to facilitation and just set a new date for us to come back should it not resolve.
All right. Okay, that makes sense to me. You don't have a date set yet, so what do you think? Sometime late in January, you might be ready on this.
It's with Carol Terzag, and I know that she's giving out early February dates, so it'd probably be safer to come back to you sometime mid-February, late February.
All right, so I'll go ahead and set a control date on this 19 case in February of 2022. I'm struggling because of how old this case is. Anyway, we'll get you back here in February. Let me see if I can find a calendar that will set us up. Just one second.
You want February 2nd?
A little later in February.
Or February the 8th?
Maybe past the 10th.
Past the 10th, you want to go, okay, so what about the 14th?
2/14/22. I'll set that on at 9:30 a.m. And I will actually, I'll actually get an order out to you as well for facilitation. I know that you've already got it set up, but it will say basically what you said. It will have that date of 2/14/22 at 9:30.
Thank you, Your Honor.
Great. Thank you, Your Honor.
All right.
Bye.
All right. Thank you. And good day to you.
You too.
Take care.
Don't we have a case in a breakout room?
No, they left. That's the one I was talking about with,
Oh. Okay.
Hello? Mhm. Oh.